Well, good afternoon, everyone, and welcome to the first Boys Turner webinar of 2025. My name is Claire Taylor-Evans, and I'm a partner here in the employment law team at Boys Turner. Now, I'm told that there are over 350 of you registered to attend this webinar, so it's really great to see so many of you on the webinar. So I'm just going to give a few more seconds just for all people to join, and then we will crack on. Okay, so many of you will know about Boys Turner already, but for those of you who don't know about Boys Turner, we are a full-service law firm, commercial law firm based in the Thames Valley. We have been described as a regional heavyweight, and we offer legal services, the full range of legal services, with a particular focus on advising clients in the technology and leisure and hospitality sectors. A little bit about me. My name's Claire Taylor-Evans. I'm a partner and experienced tribunal advocate. I've specialised in employment law for as long as I can remember, more years than I care to remember actually, since qualifying in 2003. And I have a particular interest in advising on discrimination claims and acting for clients in the technology and also leisure and hospitality sectors. And I also have a particular interest in diversity and equality. So I spend a lot of time advising clients on gender pay gap reporting and helping them devise their diversity and inclusion strategies. Now, our team is a large team. It's one of the largest in the Thames Valley. And we have the full range of employment specialists, but also immigration specialists. And we also have a dedicated employment law training academy advising and training HR teams, boards, and also managers. A little bit of housekeeping. So my aim today is to talk for around 50 minutes to an hour. If my voice holds out, so I'm covering from a terrible cold. There's lots of that going around at the moment. There's lots to get through in this webinar. I think just by seeing how many of you actually registered to come along today, everyone's very interested, and there's lots to talk about with the Employment Rights Bill. So what I would ask you to do is if you could pop any questions that you have in the Q&A at the end, and we will follow up after the event and answer any particular questions that you have. This is a live webinar. It will be going on our YouTube channel, and there will also be a listen again facility as well. So what am I going to be talking about today? Well, there was so much to choose from, but I thought I would start by giving you a tour really of some of the areas that we can expect to see in 2025. There's been quite a few changes already, with some still to come in April. I also want to focus a little bit on how businesses are getting to grips with the new duty to prevent sexual harassment in the workplace. So you'll remember this came into force towards the end of last year, so we're now 3 months on. So I wanted to talk about some of the areas that I'm seeing in practice where I feel that HR would benefit from a little bit more focus, I think, in order to discharge some of their obligations and just give you some sort of tips in that respect. No employment law webinar would be complete, of course, without talking about the Employment Rights Bill. There's lots that we don't know, but I want to focus on what we do know so far and really talk about some of the practical steps that HR can take in the next year to ensure that they're ready for some of the changes that are coming into force in 2026. So we started this year with some changes to the employment tribunal powers in relation to fire and rehire. And many of you will know that the new ACAS code on dismissal and re-engagement came into force in July last year. And it came about really because of the dreadful P&O ferry case, many of you will remember, where P&O fired 800 of its staff and replaced them with agency workers. And at the time, there was a big uproar and a call really for the whole practice of dismissal and re-engagement to be outlawed. Now, the Conservative government didn't go as far as that, but it did bring into play this ACAS code on dismissal and re-engagement. And what that essentially says is that employers need to promote fairness and transparency and enter into a dialogue really with the representatives if they are proposing to fire and rehire or dismiss all the employees in order to effect a change in terms and then offer re-engagement on those terms. There is a power to award a 25% uplift if an employer unreasonably refuses to comply with the code. So that's in relation to, obviously, the compensation for unfair dismissal. But since January, the tribunal has also had the power to award 25% uplift on any protective award where an employer fails to comply with its collective redundancy obligations. And of course, consultation on change in terms and conditions can trigger collective redundancy consultation obligations under the Trade Unions and Labour Relation Consolidation Act. And that's because the definition of redundancy is very wide and would include where an employer needs to fire and rehire or dismiss and re-engage. So that is quite important because there is now this ability for an employment tribunal to award a 25% uplift on any protective award, which, as we know, is 90 days gross pay per employee. So that's going to be substantially higher and obviously can have quite profound financial implications for employers who refuse to follow the ACAS code on dismissal and re-engagement. And we also know, don't we, that under the Employment Rights Bill, there's going to be even more sweeping changes. The proposal is that fire and rehire practices are only going to be used in very extreme financial circumstances. And there's also proposals to double the maximum protective award calculation period. So watch this space. Looking forward now to April, there are going to be some changes to the minimum wage and national living wage. So you can see there from the slide, I'm not going to read these out, but there will be some quite significant increases to the national minimum wage, depending obviously on the age bracket of the employee. Now, do bear in mind, if you are sponsoring any migrant workers, then you will need to also factor that into your pay, and you'll make sure that you're paying in line with these rates. Non-compliance with national minimum wage legislation is really quite serious. There are serious consequences, including, of course, penalties, the ability to name and shame employers who don't comply, and also criminal liability. So very, very important that you are checking that you are complying with these new increases come April. What else do we have coming up in April? Well, the normal increases to statutory sick pay is increasing from 116.75 to 118.75 a week. We're also going to have increases to other statutory rates of maternity pay, paternity, adoption, and shared parental leave as well. And we're also going to have the annual changes to the tribunal awards. So I, for one, will be very disappointed when the maximum compensatory award for unfair dismissal changes, because currently it's 115,115, which is very easy to remember. But we can expect changes to tribunal awards in April, as we do every year, but these are as yet not announced. What else can we expect in April? Well, the introduction of neonatal leave. Now, this has been bandied about for quite some time. In fact, it's been bubbling on since I think Theresa May was in power in 2019. But the Neonatal Care Leave and Pay Act received royal assent on the 24th of May 2023. And we received notification from the government a few weeks ago now that it will be introduced with enabling regulations anticipated by the 6th of April this year. So what is this new right? Well, it's going to be a day one right for individuals to take time off work to care for babies who need neonatal care. And the right is to take up to 12 weeks. And the baby must have been admitted to neonatal care within the first 28 days of its life in order to qualify. And the baby must have stayed in hospital for at least 7 consecutive days. The right is to leave of up to 12 weeks. In order to receive pay, the parent must have been employed at least 26 weeks by the employer. So this mirrors the statutory maternity leave scheme here. And the leave can be taken in blocks of 1 week up to a maximum of 12 weeks. The leave must be taken within 68 weeks of the baby's birth, and it will apply to both parents. And what's important, I think, to bear in mind here is that the leave is in addition to other leave entitlements. So in addition to the maternity leave, etc., entitlements. So that is really, really good news, I think, for new parents. It's estimated it will benefit 60,000 new parents and allow them to spend time with their baby. Obviously, if their baby is born poorly, it will allow them to spend time with their baby without eating into their other statutory leave. So what could you do now? Well, we are awaiting further information in relation to this. So the actual finer details of the leave, we are waiting to hear. But as soon as we have those, then you should be having on your radar to update your policies and make sure that your employees are aware of this new right. We're also going to have changes to employer NI contributions on the 6th of April 2025. So the primary rate of national insurance contributions, which employers currently pay on employees' earnings, will rise from 13.8% to 15%. And the earnings threshold at which they start paying it will also drop from £9,100 to £5,000 per year. So significant increase in terms of finances for employers there to watch out for. What else do you need to be thinking about? In April, I always get very, very busy around the April period because I do a lot of gender pay gap reports for clients. So for those of you who are caught by the gender pay gap reporting regulations, which, as we know, came into force in 2017, if you employ over 250 employees on the snapshot date of the 5th of April the previous year, then you do need to report on your gender pay gap by the following 4th of April, so by the 4th of April this year. And of course, the obligation is to carry out a set of calculations, quite complex calculations, and make sure that you report those calculations and submit them to the government, who then publish it on their government website. So just do bear in mind that you haven't crept over the threshold in the last year. So look at your workforce data on the 4th of April and make sure that you haven't, particularly if you're coming up to the 250 employee mark, just to make sure that you haven't tripped into being caught by those regulations. And if so, do make sure that you are ready to report on that. Lots of companies are voluntarily reporting on their gender pay gap, and we will see, of course, under the Employment Rights Bill, increased focus, I think, on pay equity and reporting, not only for gender pay, but also for disability and ethnicity pay gap reporting. So it's a good idea to have this on your radar now, if you don't already, and consider voluntary reporting, or at the very least, putting in steps to start capturing that data. We are also anticipating a new paternity leave for bereaved partners. So this was actually proposed by the previous Conservative government, and Labour did say that if they were to get into power, they would pass the necessary enabling legislation. But we as yet don't have a date for this, although we do anticipate it will come into force at some point this year. So the idea with this leave is for to be a paternity bereavement leave if the mother or adopter of a child dies within the first year. And it is a day one right, so there's not going to be a requirement for 26 weeks qualifying service, as we see with lots of other statutory leave. It is going to be a day one right. And we do expect, obviously, to get much further information on this new right, but it is likely to be 52 weeks leave presently. Now, when the government were consulting on this, they gave some statistics, and apparently there are around 180 maternal deaths a year. So this leave will probably only apply to a very small proportion of cases, but nevertheless it is very important. So wait and see what will happen with that. I just wanted to touch now really on the law that came into force, the new law that came into force last year in October, which is the new duty to prevent sexual harassment in the workplace. And I just wanted to do a quick recap of what that law was. And really ask you what reasonable steps you've put in place since it came into force in October last year, because we are now 3 months on, and it is a proactive and positive duty on employers to take reasonable steps to prevent sexual harassment in the workforce. So just a quick recap. The new duty, as I say, requires employers to take reasonable steps to prevent sexual harassment, which was unwanted conduct of a sexual nature, during the course of employment. And it came into force on the 26th of October 2024. It is a positive and proactive duty, and the whole idea was that the previous law really didn't go far enough. And the aim of this law really was to transform workplace culture, because sexual harassment thrives on a culture of silence, on a culture of acceptance. And the idea behind this law was to require employers to really anticipate some of the risks of sexual harassment and to put in place steps to obviously mitigate those risks. Now, what are reasonable steps? Well, it isn't prescribed under the legislation, but it will depend on the size of the employer, the sector in which it operates, and also the working environment. And obviously, if there is a high risk environment, then the resources that an employer would be required to take to discharge the duty, or the steps they would be required to take, would be even more onerous to do that. Enforcement, so it is not a standalone claim, so it can't be brought in the employment tribunal unless there is a successful claim for sexual harassment. And if there is a successful claim for sexual harassment, then there is an ability for the employment tribunal to uplift the compensation by up to 25% if it feels that the employer did not take reasonable steps to prevent sexual harassment. There are also important new powers by a regulatory body, the Equalities and Human Rights Commission, to go into organisations and investigate to see if they are doing enough to discharge their duty, to take out injunctions, to issue unlawful action notices, to require employers to enter into legally binding agreements, and also to name and shame employers. And EHRC have actually said that they are going to take robust enforcement action. What about third parties? Well, there isn't actually liability for an employer currently for in the employment tribunal at least, to be sued for failing to prevent sexual harassment of its employees by a third party. But certainly the EHRC suggests that an employer can be liable for acts of third parties. And they have also said that they will investigate complaints of third-party sexual harassment. So there is quite a wide duty by this new, wide powers, I should say, by this new regulatory body to come in and take steps in respect of third parties. We also know, don't we, that there are going to be even further obligations under the Employment Rights Bill. So sexual harassment will be defined as a protected disclosure under the Employment Rights Bill, under whistleblowing legislation. And currently, of course, under the Worker Protection Act, there is an obligation to take reasonable steps. Under the Employment Rights Bill, there will be an obligation on employers to take all reasonable steps, so a much, much higher duty. And liability, as it says there on the slide, for third-party harassment will actually be introduced under the Employment Rights Bill. So there will be liability and an ability for employees to sue employers in the employment tribunal for failing to take steps to prevent harassment by third parties. So that's clients, contractors, customers, suppliers, anyone that your employees interact with in the course of their employment. You need to be taking steps to prevent sexual harassment of your employees by those individuals. Adding to the mix, a new private members bill. So this was announced recently. A new private members bill has been proposed to extend the health and safety obligations under the Health and Safety at Work Act 1974 to prevent sexual harassment. So this will be to add specific obligations to address violence and harassment in the workplace with a particular focus on sexual harassment. It's currently going through Parliament, the private members bill, and there is a second reading on the 7th of March 2025. But if this bill is passed, and that is a big if, of course, but if it is, then it will require similar obligations to the Worker Protection Act. So that would be risk assessments, training, policies and procedures to deal with preventing sexual harassment in the workplace. But there will be an additional enforcement ability by, not just as is the case under the Worker Protection Act at the moment, by the ECHR. This will be governed by the Health and Safety Executive and will be able to be enforced by them. And in addition, there will be criminal liability on employers for failing to comply with these provisions if it indeed comes into force. So we can see, I think, from all of that, the direction of travel in this area and why it really is so important and why these organisations, the regulatory bodies, and the government are taking it so seriously. Excuse me. So that being the case, what are reasonable steps? What reasonable steps has your organisation taken since October to make sure that you are discharging your duty? Now, in my experience of dealing with clients, I've seen lots of clients wanting their policies updated. I've seen lots of clients saying, we don't have an issue with this because we don't have any complaints of sexual harassment in our workplace. And what I would say to that is most complaints of sexual harassment do go unreported. So I think 79% of all complaints of sexual harassment go unreported because there are lots of factors that come into play, but the fear of reprisal, a culture of acceptance, a fear of not knowing that your complaint will be taken seriously. So a whole heap of factors why individuals don't actually report complaints of sexual harassment. So the fact that you are not actually seeing complaints in your organisation, of course, doesn't mean that it isn't going on. And the new duty actually requires you to go much further than that and to actually anticipate risks of it actually occurring, even if it doesn't already. So risk assessment is really, really important priority action. And the Equalities and Human Rights Commission has actually said in its guidance that an employer is unlikely to be able to comply with its preventative duty unless it has carried out a risk assessment. And what I am seeing in practice is a lot of organisations are actually missing out this important first step, or in fact, they are doing the risk assessment, but in a very sort of perfunctory tick box exercise way, which in my opinion wouldn't go far enough to enable them to discharge their duty under the Worker Protection Act. So I would say that is absolute priority for organisations to make sure you are carrying out a comprehensive risk assessment. And of course, that risk assessment will inform the actions that you need to take as an organisation. So that should inform your policy reviews, and also in your policies, you should be referring to the risks that you have identified in your risk assessment. It will also inform the gaps in your organisation's policy. So you may need to be training your board on the importance of the new law. You may need to be training your managers to recognise and spot signs of sexual harassment, what to do if they have a complaint of sexual harassment. You may need to be training your workers to make sure that they're aware of what constitutes sexual harassment and what they need to do in order to complain, and also getting feedback from your workers on whether they actually feel that there is a culture in your organisation where they can speak up and where they can speak up on behalf of others as well. So ensuring employees are trained and that they are also trained on bystander training. So I think a really big piece of work for HR at the moment, even though we're only 3 months in, as I say, I do see that there is quite a lot of work still to be done, I think, in this area. So I now want to turn to the Employment Rights Bill. What do we know? We know some information so far. There's lots we still don't know. But I thought I would focus now on what we do know and talk about some practical steps that I think HR can put in place in the next year before the majority of changes are expected in 2026. So Labour did confirm that they would pass the Employment Rights Bill within 100 days of being elected. They managed to do it just in the nick of time on day 98. And as one might imagine, with a self-imposed deadline in that respect, it was quite a rushed piece of legislation. So it was published on the 10th of October 2024, quite lacking in detail. There were key areas conspicuous by their absence that were promised in the Labour manifesto. And obviously, with such a wide-ranging transformative piece of legislation, there is a requirement for the government to consult at length with stakeholders and gain significant input from business groups and other interested parties. Now, some of those consultations have already started. They started prior to Christmas and some have closed, but the majority of consultations are going to be launched this year. It is currently the bill at parliamentary committee stage, so the second reading is taking place in Parliament this month, and the committee is due to report back this month. And our best guess is that the bill is likely to pass by the middle of this year, but obviously then it will require regulations further down the line to actually implement the bill. So the majority of the reforms we can expect will take effect no earlier than 2026. So whilst we don't expect to see any significant changes until 2026, there are some areas I think that I would like to focus on for the purposes of today's webinar, where I think it's important to just talk about some of the proposals and also some of the steps that you as a business can take in anticipation of the proposals coming into force in 2026. So the first of those is, of course, unfair dismissal. So this is one of the most significant reforms, I think, proposed by the Employment Rights Bill, and that was to remove the qualifying period for unfair dismissal. So we know that the qualifying period for unfair dismissal has changed according to the colour of the government. I think at various points in my career, it's been at 6 months, it was at 1 year at one stage, and it's currently at 2 years. So employees who have 2 years service have the right not to be unfairly dismissed currently. So the proposal under the Employment Rights Bill is to remove that so that unfair dismissal will essentially become a day one right. Now, there is proposals under the Employment Rights Bill for a statutory probationary period, essentially, or what's known as an IPE, an initial period of employment. And during that initial period of employment, dismissals will be able to be effected with a different standard of reasonableness, essentially. So it's not going to require the employer to go through the full potentially fair reason and potentially fair process that we currently have and recognise under employment law. How long is that initial period of employment going to be? It's as yet undefined, but the government have indicated that it's likely to be 9 months, although they are consulting on this proposal. And this standard of reasonableness, different standard of reasonableness, will apply to dismissals that happen during that initial period of employment or after the initial period of employment has ended, provided notice has been given during the initial period of employment and ends within the 3 months of that initial period of employment. So let's take, for example, a 3-month notice period. Provided you were to give notice during the initial period of employment, if that was to then take effect within 3 months of the end of that 9-month initial period of employment, assuming that it is going to be 9 months, essentially a 12-month period within which you can take that action. Now, the idea is that during the initial period of employment, you can follow a light touch procedure, as long as your dismissal or your reason for dismissal of the employee is for one of these reasons. So what reasons are those? Conduct, we're all familiar with conduct as a potentially fair reason for dismissal, so generally misconduct of an employee. Capability, so this is where an employee is incapable of performing their role, either because they can't perform their role because of ill health, or they're unable to perform their role because of performance issues. So that would fall under capability. Illegality or breach of a statutory enactment. Often we see this, for example, where an individual perhaps loses their driving licence and they require that for undertaking their job. And then the final reason under which you can use this light touch procedure during the IPE is SOSR, or as we know it, sum of the substantial reason, which is essentially a catch-all for all other reasons for dismissal. Now, I've put there on the slide, but not as we know it, because SOSR is often used, for example, in business reorganisations or restructuring. Importantly, under the Employment Rights Bill, the reason for dismissal to be able to use this light touch procedure in the initial period of employment must relate to the employee. Now, I'll come on to what that might mean in a minute, but it's not SOSR as we currently know it. Now, do note that it doesn't apply to redundancy. So if you are making an employee redundant, then you will be required to follow the full fair process, potentially fair reason for dismissal process, potentially for redundancy from day one, essentially. So it doesn't apply to redundancy dismissals during those 9 months. There are currently no proposals to change the qualifying period of employment to get a redundancy payment. So that will remain unchanged, that you will need to serve 2 years service in order to qualify for a statutory redundancy payment. So lots of questions there, I think. The first, obviously, is what is the light touch procedure? Well, we don't know. Is the honest answer. We don't know yet, but our best guess is that it will require at the very least a meeting with the employee, possibly the right to be accompanied, and the provision of written reasons for dismissal. So query, is that actually going to be hugely different to what you might do anyway? Certainly when we are advising clients who are dismissing employees with less than 2 years service, we always ask them, are there any automatic and fair dismissal grounds for which you obviously don't require any qualifying period of employment? Are there any discrimination grounds or protected characteristics that could be argued? And in order, obviously, to ensure that the employer protects themselves, we would ordinarily be expecting them to provide written reasons for dismissal. So is this going to be wildly different to what you do anyway? The other question that occurs to me is how does this fit with contractual probationary periods? So often under an employment contract, you will have perhaps a 3-month contractual probationary period, during which time you can terminate on a lesser period of notice, normally 1 week. How is this all going to fit together with this IPE? Conceivably, you could have an employee who has passed their contractual probationary period, but then is subsequently dismissed during the IPE, if it's at 9 months, obviously longer than the contractual probationary period. Will there be a requirement to dovetail your contractual probationary periods with the statutory probationary period? And what about pay in lieu of notice? Are we likely to be able as employers to still exercise the right to pay in lieu of notice during the initial period of employment? Now, I think the answer to that is going to be yes, provided it takes effect within the initial period of employment or within 3 months of the end of the initial period of employment. Now, many employment lawyers are very concerned about what this light touch procedure could look like, because many of you will remember the statutory disciplinary and dismissal procedures which were enforced in the 2000s, which created a whole load of satellite litigation. So great news for lawyers, but not great news for employers. So we do hope there will be some further clarity on this in due course to avoid a repeat of that. Other questions we don't know the answer to. Will you need to prove the reason, or will it be sufficient for you to just say that you are relying on, for example, conduct or capability? What SOSR reasons might relate to the particular employee? So certainly not reorganisation or restructuring. That wouldn't relate to the particular employee, but potentially personality clashes. That could be an SOSR reason that you may be able to use in order to exercise the light touch procedure during the 9-month IPE. Will there be less compensation for employees if they're dismissed during the IPE? Well, the answer to that is probably yes. There has been a consultation announced on reducing the compensation to be awarded to employees for dismissals during the IPE. Discrimination and automatic unfair dismissal rights will still apply. As I say, you don't need to panic in respect of this. It's not expected until autumn 2026. But it is good practice to put some steps in place, which I'll come on to shortly, in anticipation of this. What about the impact on claims? We know we're already struggling with an overwhelmed employment tribunal system, and it's estimated that an additional 9 million more people will be able to bring unfair dismissal claims based on these new rights. Who's going to fund the resources? Is there going to be an increased role for ACAS? Only time will tell, but it's going to be interesting to see the impact on the claims and the employment tribunals. And also, will businesses take fewer chances now with their recruitment process? And also, how would it apply if you are to introduce perhaps a 9-month probationary period? How will that impact on your ability to recruit talent? Is everybody going to be happy with a 9-month probationary period? So lots of questions. But what can you do now as an employer? I would say the first thing is to look at your probationary periods. How long do you need to assess if someone is suitable? Do you need to think about aligning them to 9 months, and how would that work in practice? Look at how your managers are currently handling probationary starters. So we know from my experience in practice that managers are very, very busy people, and they're not always great at managing employees during their probationary period. And we often see the first we'll hear of a poor performing employee is immediately after they've passed probation. So the manager will come and say, actually, he's rubbish. But of course, he's now past probation, and it's much more difficult to dismiss. It's going to become much more important going forward for managers to be on the ball with probationary review periods, and for employers to have processes in place that come into play well in advance of the 9-month IPE. And if you are getting your managers on board now and training them and making sure that you have processes in place, it will become second nature when the new Employment Rights Bill comes into force. So look at your policies, look at your processes, look at upskilling your manager and making sure that they're aware of how important it is that they are managing the probationary period properly. What else can we expect to see under the Employment Rights Bill? Well, there's going to be an extension to the time limit to bring claims. Currently, as we know, most claims you have to bring within 3 months. That's going to be likely to be extended to 6 months. Again, is that going to cause more delay in the employment tribunals? Possibly. It's probably going to impact on claims, although question whether perhaps with a bit more time to think about it, that sort of grief window when a claimant is initially dismissed, perhaps the anger will go if they have a bit more time within which to bring a claim. So that might impact obviously on claims, but it certainly is going to impact on witnesses, because witnesses are not necessarily going to still be employed by the employer 6 months after the event. So it's more important than ever for employers to put in place litigation assistance clauses in settlement agreements, I would say, going forward. So do look at your contractual documentation and any settlement agreements as well to make sure that you are including those clauses. Another big area, I think, of reform and an area that you can look at now is the changes to 0-hour contracts. So we were promised under the manifesto outlawing essentially exploitative 0-hour contracts. That didn't quite happen. Instead, we got guaranteed hours must be offered by employers. And the hours must reflect those worked in the reference period, which we don't yet know what that is, but it's likely to be 12 weeks. Workers will be able to bring employment tribunal claims if those hours aren't offered to them. And there will also be a requirement for employers to give reasonable notice of any changes in shifts or working time, with proportionate compensation payable for any shifts cancelled or curtailed at short notice. Now, do bear in mind that there is only a right to be offered these guaranteed hours, so the worker doesn't have to accept the guaranteed hours. Potential claims that can be brought are if an employer fails to offer guaranteed hours, or they don't comply with the offer requirements once they've offered them, or if the worker is subjected to a dismissal or detriment for exercising their rights, or if they're dismissed for rejecting or accepting the offer. And what is that likely to look like in terms of compensation? Well, probably certainly for failure to offer the guaranteed hours, it's going to be probably just an equitable compensation based on what those hours would have been. Lots of questions on this topic as well. What on earth is a low hours worker? We don't yet know. There has been talk of it being around 15 hours. We do a lot of work in the leisure and hospitality industry, and they're obviously very concerned about this. They would like to see a number that doesn't involve weekend staff being caught. So if you are in this industry and you're likely to be affected by these proposals, please do feed into consultations to the government. We're doing a lot of work on behalf of our clients and putting forward some of these questions, so do get in touch if you'd like to contribute. What about seasonal demand? You don't necessarily want to offer your workers guaranteed hours if perhaps you've taken them on during a peak period and that period isn't then going to be replicated in the future. So is there going to be an exemption to this? There does appear to be an exemption for limited term contracts in the event of limiting events. So I think there will be an exemption, but it's something that you will need to look to gather some evidence of if you want to use that. How long will you have to make the offer, and how long will the worker have to respond? That response period is as yet undefined, but you can see how in practice this could affect your ability to offer those hours to other workers and create quite a resourcing headache. And what is reasonable notice of a shift change? What if somebody is ill and it's unexpected and you need to get somebody to change shifts at short notice? Will there be any exemption in respect of that? So lots of questions, but what can you be doing now in order to mitigate some of these steps going forward? The first I would say is if you rely on 0 hours contracts, then you need to carry out an audit. Track demands of work. So if you do have peak periods, you may be able to demonstrate some evidence to fall within that exemption that I talked about. So do make sure you've got the data. Look at your shifts and how much notice you currently give of changes to shift. Look at perhaps an average and a snapshot across the business of how you deal with shift changes, etc. And make sure you're getting that data so that you will be able to look at whether you can take any steps to mitigate or be compliant as and when these new changes come into force. I just want to talk really quickly about potential changes to collective consultation, which are also planned under the Employment Rights Bill. There will be a removal of the establishment trigger, so more collective redundancies will potentially be caught, and this will have a big impact for employers. When I talk about establishment, under the Trade Union Labour Relation Consolidation Act, where employers are proposing to dismiss as redundant at one establishment within a 90-day period, they must collectively consult with elected representatives. And we know that If that involves 20 or more proposed dismissals, they must consult for 30 days before the first dismissal takes effect. And there's essentially a moratorium on that dismissal taking effect. And where there are 100 or more, at least 45 days before the first dismissal takes effect. Now, it's established case law since the Woolworths case that one establishment is generally a geographical location. So if you have multi-sites, currently under current law, those numbers are only counted across those individual sites. But going forward under the Employment Rights Bill, the proposal is that establishment test will be removed so that you will need to look across the whole business when coming to count up the numbers of proposed dismissals. There's also been a consultation announced on increasing that consultation period from 45 to 90 days, and also removing the cap on the protective award. So currently that is 90 days gross pay, and there is a proposal to remove that cap. So what does that mean? Well, it's going to be much harder. There'll be much more delays in the collective consultation process if these proposals are implemented. Much more difficult for employers. And of course, if you get it wrong, and it is easy to get collective consultation wrong, it will be much more costly. So what can you do now? Have a look if you have a way of tracking proposed dismissals across multiple sites of your business. Have a look if you have that visibility to be able to put that in place easily in the future. The other thing I would say is consider appointing employee representatives in advance. In my experience of collective consultation, the part that is the most difficult for employers and delays the process, extends the process, and of course this part needs to take place before those minimum prescribed periods that I just talked about on the slide, is the electing of the appropriate representatives with which to consult. So you do have time now to consider appointing some employee representatives, perhaps having a staff council or a work council. And it also gives you an opportunity now to set the mandate and the terms of reference. So do consider perhaps putting in place those representatives now to save you time in the future. I just want to talk really quickly, because I'm running out of time, about union powers. So a huge area of reform, trade union reform under the Employment Rights Bill. I'm not going to have time to go through all of the provisions, but we will be sending out some information after this. But I suppose the upshot is there's going to be it's going to be much easier for unions to get a foothold into businesses. Currently, you have to tell employees whether there's any collective bargaining agreement that applies to their employment. But going forward, you're going to have to notify employees of their right to join a union, and you will need to put this in writing and on a regular basis. There's going to be a new right of access for unions, lower thresholds to get recognition, repealing restrictions on industrial action, which are currently in force, and a whole raft of changes on protection for union reps. So the upshot of that is it's going to be, as I say, much easier for unions to get a foothold. Many businesses won't have had to deal with unions to date, so it's more important than ever for you to adopt good industrial relations strategies and ensure effective measures are in place to engage with employees. What I would say is training is hugely important in this area. So we are going to be running some particular training sessions on unions and trade union reform. So do watch this space and look out to get yourself booked on for some of that training, because I think this is going to be a big area of focus for HR going forward. Some of the quick changes that we are just waiting to see, obviously improved statutory sick pay, the introduction of equality action plans for those who employ over 250 employees, a single enforcement body to deal with holiday pay, changes to flexible working regulations. So we currently have to deal with requests in a reasonable manner. There's going to be a much more focus, I think, going forward on the reasonableness of the refusal and justification. There's going to be a whole reform of the family leave framework, so we can expect to see perhaps paid carers leave, bereavement leave, introduction of day one right to paternity leave, and also introduction of day one right to parental leave. We're expecting a review on that in July, so do watch this space on that, and also increased protection for those returning from maternity leave as well. So that was a massive whistle-stop tour. I just wanted to highlight here, I think, some final thoughts to leave you with. Sexual harassment, I talked about. I think this is a real priority. If you haven't yet done anything, you are at risk already, because it is an anticipatory duty and a proactive duty. So you need to have done something already, at the very least conduct a risk assessment or ask us to do it for you. We are doing a lot of work with clients in this area. You can obviously do your own risk assessment, but there is some value, I think, in appointing an external third party to do this, because it removes the risk of sort of groupthink, and obviously we're very experienced in identifying risks in various sectors in which we act. Training for your staff, HR, board and managers is really, really key. Again, we can help you with this. And updating your anti-harassment, whistleblowing, equal opportunities and electronic communication policies. And then on the employment rights bill, don't expect any massive changes. There's probably going to be some minor changes to the trade union rights, probably this year, the latter part of this year. But you have got a year really to prepare for some of these changes. And so I would say start making sure your managers are trained on onboarding and managing employees properly during the probationary periods. Make sure you've got really robust processes in place. Carry out audits if you rely on workers under 0-hour contracts, and look if you've got any particular risk areas, areas where you can collate some data to use as evidence in the future. Make sure you're trained on unions and also new collective redundancy obligations, and that can include manager training as well. I think that's very important going forward. And of course, update your policies, particularly with your neonatal leave, and feed into consultations. So it's really, really important that you your voice is heard, particularly if you are impacted by some of these issues. So we are collating responses on behalf of clients, so do please get in touch if you would like us to do that on your behalf. Just remains for me to say thank you very much for attending today. I'm sure there will have been questions, and I'm sorry I didn't have time to deal with all of them, or any of them, in fact, because there's just so much to get through. But please do put them in the Q&A, and we will be following up each and every question that you have after the event. Thank you very much for listening, and I will see you again. Thank you.